Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about opioids, addiction, and lawsuits, so stay tuned. So before I get started, let me just say this. Opioid addiction, like any addiction, is a terrible thing. The people who are addicted to opioids didn't start out to become addicted to opioids. They started out trying to alleviate their pain. And the opioids simply made them feel so good that they needed more and more and more, and eventually became addicted. A lot of them resulted in driving themselves into a life of crime. It is an absolutely terrible thing to become addicted to something as powerful as a very strong opioids. And unfortunately, that's happened to hundreds of thousands of people all throughout the United States. And the state attorney generals decided to do something about it. And so they took a page out of the playbook of the attorney generals from the 1990s who went after the big tobacco. Only instead of using the false marketing and Consumer Protection Act strategy that had been used in those cases, they used a rather controversial approach called public nuisance. Public nuisance is different than private nuisance. For example, if you have a nice little piece of land on the edge of the city and you're not in the city, but you're close enough that you can drive in and get a cup of coffee in the morning if you want it. And then the 15 acres behind you gets purchased by a company that wants to build a pig farm, and they build a pig farm that can hold 500 hogs. That's going to produce an enormous amount of waste from those pigs. And you're going to get overrun with flies and all kinds of stuff. So nuisance law exists to protect you there. It can make, in many cases, it can make that pig farm remediate the nuisance. In other words, do things to stop the smell, do things to stop the flies, all of that. And that's a good thing. That's what nuisance law, or I should say private nuisance law, is designed to remedy. Public nuisance law was designed basically to go after criminal activity. Houses of prostitution, speakeasies during the 1920s, the Roaring Twenties, during Prohibition. They were designed to eliminate nuisances that affected the whole of a population, not one or two people in it. And so the attorneys general took this approach and they started suing Johnson & Johnson, Endo, Teva, Purdue Pharma. And indeed, they drove Purdue Pharma right into bankruptcy. They supposedly drove Mallinckrodt directly into bankruptcy. And all of these suits produced piles and piles of paperwork that showed, in some respect, with respect to some defendants, that they had been responsible for marketing their drugs in such a way as to almost assure addiction. And also that they hadn't exactly been forthright when they found out that a doctor was operating what's called a pill mill, where you walk in and say, "Oh, doc, I got a headache," and they go, "Oh man, you need an opioid," and so you walk out with a script for opioid narcotics and you become addicted, and that happens. So the public nuisance theory was designed to redress what the attorneys general saw as a wrong that affected the public. So the last couple of years, there have been some settlements. There have been some good moves by the attorneys general to rectify this problem. But then the first trial under this public nuisance doctrine came up in California about 3 weeks ago, and it was a judge-tried case, meaning they didn't get a jury. And the judge came to the end of the trial and said, I'm sorry, this theory doesn't work. No, you don't get any money. Zero, zilch, goose egg. That's what you take away from the opioid companies. And two things happen. First, the attorneys general went, and second, the opioid companies went, hey, that's pretty good. Well, one win does not a wave create. But then last week, the Oklahoma Supreme Court came out with an opinion and basically said, hey, this doesn't work.
In Oklahoma, part of the law is based on statute. A public nuisance is one which affects at the same time an entire community or neighborhood or any considerable number of persons, although the extent of the annoyance or damage inflicted upon the individuals may be unequal. At first blanch, that would certainly seem to meet the standard for this opioid crisis, but that's not what the Oklahoma Supreme Court eventually wound up determining. Here's where the Oklahoma District Court went wrong according to the Oklahoma Supreme Court. The District Court held that J&J was liable under Oklahoma's Public Nuisance statute for conducting false, misleading, and dangerous marketing campaigns about prescription opioids. The District Court had ordered J&J to pay $465 million to fund 1 year of the state's abatement plan, which consisted of the District Court apportioning money to 21 government agencies. And here are some other things the District Court did wrong. The amount of the judgment was not based on J&J's percentage of prescription opioids sold. The court also didn't take into consideration or grant J&J a set-off for the settlements the state had entered into with other opioid manufacturers. Instead, the District Court held Johnson & Johnson responsible to abate alleged harms done by all opioids, not just the opioids manufactured and sold by Johnson & Johnson.
After Johnson & Johnson sells its product to a pharmacy, it loses control over it. And public nuisance has always been about the people who had control over the bad thing.
So this is where the Oklahoma Supreme Court wound up. The court has allowed public nuisance claims to address discrete, localized problems, not policy problems. Erasing the traditional limits on nuisance liability leaves Oklahoma's nuisance statute impermissibly vague. The district court's expansion of public nuisance law allows courts to manage public policy that should be dealt with by the legislative and executive branches, the branches that are more capable than courts to balance the competing interests at play. The court defers the policymaking to the legislative and executive branches and rejects the unprecedented expansion of public nuisance law. The district court erred in finding Johnson & Johnson's conduct was responsible.
The Oklahoma Supreme Court's opinion is well-written, well-reasoned, and an actual great opinion because it properly states the law and it properly applies the law. This is a good opinion, and the reason it's a good opinion is because it properly states the law. Now, that doesn't mean that the states can't go back to the drug companies and get money from them under an appropriate legal theory. Nobody questions that that could happen. The issue may be trying to figure out what that proper legal theory is. And of course, they've done discovery in these cases, so they have all of the documents, and it's quite possible they could put together a theory that would prevail in a court of law. But they haven't done so yet. And it's interesting because they've forced several of these companies into bankruptcy trying to defend these lawsuits under a theory that never had any applicability. And that should give all of us some pause. Now, in some of these other states, it may very well be that they accept this public nuisance theory, but when they do, it will go up to the United States Supreme Court. And it's difficult to tell without seeing what issues get presented to the United States Supreme Court how that court would react. But I can tell you this, they have generally not been particularly friendly to plaintiffs' lawyers and even to state attorney generals when they have been trying to recover billions of dollars from corporations. That's not really a criticism of the Supreme Court, it's just a statement of fact. And our Supreme Court exists to make sure that the law applies fairly to everybody, from the person working for $15 an hour at McDonald's to the person working for $15 million a year at a drug company. And that's what their job is. The courts exist to make sure that the rules apply to everybody. Doesn't always mean that they do, but that's what the goal is. So that's the story of opioids. It's pretty clear that the lawyers picked a bad strategy and it didn't play out. We'll have to see what happens as this goes forward. But I thought I'd bring this to you because it does tend to impact a lot of different people. If you have thoughts about this and would like to share them in the comments, please do. Just remember to keep them family friendly. There are a lot of good people who come by here and read the comments, so I'd appreciate it if you do that. If you've enjoyed this or found it useful, or I told you something maybe you didn't know, I would love to see a thumbs up on here. And in addition to that, if you haven't already, please go over here and subscribe to our channel and touch the notification bell so that you can be notified anytime we release a video on this channel. Thank you very much for watching. I hope you have a terrific day, and I will catch you on here next time.